everyone. Welcome to the Legal Studies Units 3 and 4 lecture, as well as the ATAR Notes July lecture series. My name is Sunny. I'm really excited to be delivering this presentation to you all today, and I really hope that it helps you with the subject. So just on these slides, you can see some resources that you can access through ATAR Notes for your subject, as well as some additional supports if you need some extra help. Let's get started and jump right into the lecture. So I'll introduce myself first. So just to start, a little bit of information about myself. I graduated in 2021 as the college dux of my school with an ATAR of 96.70. In terms of legal studies, I received a study score of 47 and 40 plus in my other subjects such as English, literature, English language, further maths, and psychology. And I'm currently studying a Bachelor of Paramedicine at Monash University, and I am in my second year of the degree. So this is the layout of how today is going to run. Essentially, we're going through all of Unit 4 content. So I'm sure you guys have started this first area of study already and looked at a lot of it. But we'll go even more in depth and have an easy breakdown that will really put you ahead in terms of legal studies about the people, the parliament, and the courts. So your next area of study. It won't be confusing. You'll actually find that there's a lot of overlap between the things that you learn in Unit 4 Area of Study 1 and Unit 4 Area of Study 2. Kind of similar to Unit 3 Criminal versus Civil Justice System. So that's how we're going to go. And if you have any questions come up as we're going through the lecture, utilize the live chat to ask me and I'll answer any of your questions. All right, so first thing, we'll look at the study design. So this shows all of the key knowledge dot points that you need to be able to answer questions for in Unit 4, Area of Study 1. So I really want to stress the importance of always having a look at the study design because it shows exactly what you will be assessed on, what kinds of questions you can get, and everything that you need to know. So literally having it printed, annotated, sitting on your desk, so you can have a look and see, oh yes, I do know all this stuff. I can answer all of these questions. I cannot stress the importance enough. So literally we will cover everything in short detail. Some things will go more in depth. Feel free to have a look at all of the dot points there. And the key skills dot points, these are actually really important and often underrated by students because they tell you exactly what kind of questions you will get for the various dot points in the study design. So, for example, for the Australian Constitution, acting as a check on Parliament in lawmaking literally specifies that you will have evaluate questions for this. So you need to be able to evaluate all the 5 ways in which the Australian Constitution acts as a check on Parliament. You can also use them to form practice questions for yourself. It's nothing difficult, legal studies questions are very, very straightforward. You don't need to make a case study, but if you're looking to write just short answer, extended response questions, you can take that directly from the key skills dot points. Let's jump right in. Beginning to look at Unit 4 Area of Study 1, we'll start with the composition of Parliament. So, this is crucial for you to understand because this is what you study for the rest of the year. So this knowledge you have to have. Obviously, we have the lower house, which is very, very important. House of Representatives in the Commonwealth Parliament and in the State Parliament in Victoria, it is called the Legislative Assembly. This is the house that forms government, either Commonwealth level or state level government. So the party with the majority of seats in the lower house after an election, they come together and they form what's called executive or representative government, or really both. And that's your major party with the majority of seats. They can pass through laws quickly because they have the majority of seats in the House, so they can just approve them. And therefore, this house is very, very important. Then we have our upper house, which is our house of review, often referred to that way because this is where laws are not usually introduced, but a bill, a proposed law, is usually raised in the lower house it goes through the three reading steps there, gets approved, and it goes to the Senate, where it also needs to go through these steps and also be approved. In turn, they often actually review the legislation and scrutinize and debate the legislation rather than introducing it themselves, even though they have the power to do so. So, this is the Senate in the Commonwealth Parliament, and in the state parliament, this is the Legislative Council. We won't go into detail about the composition of each house, just be aware that that's something you need to be aware of. And it's different at state level and parliament level as well. So don't get them mixed up. And also watch out for the names, don't get them mixed up. So, lastly, at the very top of the pyramid, technically has the most power, the Queen's representative, the Crown. We know, however, that the Crown, the monarch in England, doesn't really do this. They don't partake in lawmaking and and do anything really. So they're actually represented by the Governor General, which is the Crown's representative in the Commonwealth Parliament. And in the state parliament, this is the governor. So make sure you remember this and don't confuse this and lose marks when you're responding to questions. All right, so understanding the levels of parliament might not be the easiest thing, but it's the understanding that you have to have first, and then you'll quite easily be able to memorize everything. Hopefully, you guys are finding Unit 4 all right. I know it is very different from Unit 3. So we'll look at the roles of the lower houses first. These are, as we said, the House of Representatives at the Commonwealth level, and at Victorian level, it is the Legislative Assembly. So what are the roles of the lower house? As we established, they form government. The party with the majority of seats following the election will form government. The leader at Commonwealth level will become the Prime Minister, and they will decide for other members of their party to become ministers. Essentially, with some administrative powers, which we'll look at the powers, separation of powers soon. And they're going to be able to do various things. You've heard of things like education minister, health minister, treasurer. So the titles kind of denote the roles that the ministers can sort of have. And there will be other parties, of course, in the lower house. They will not have as much power on their own. If we do have a clear majority in the lower house, they won't be able to really stop laws from passing through there because the government party itself will have more than 50% of members being able to vote bills through. They won't be able to stop laws, and if they do initiate laws without the support of the government party and their approval and their vote, yes, um, it's not going to be able to pass through. So the lower house also initiates, debates, and votes on bills. This is a role that the Senate has also, the upper house also possesses. You can see that there's a lot of overlap between the roles. We talked about the bill initiation already, but someone will step forward, such as a minister will step forward and propose a bill, and debating and voting happens in both houses on every bill because it needs to pass through both houses. They also control government spending, so they can initiate and pass money bills, um, and yeah, essentially decide how money should be spent on the country. The Senate or the upper house cannot do this. So this is a difference in their roles. They don't work, they don't handle money bills. It can also act as a house of review, but we talked about how this is mainly a role of the upper house rather than the lower house, reviewing and scrutinizing laws simply because of oftentimes how usually their composition is. And that being that usually the Senate has a different composition to the House of Representatives, with different parties having more members there, and then they can actually halt laws, ask for amendments in return for their support for the bill, um, or reject them if they deem them to be inappropriate. So the lower house can scrutinize government, so can the Senate, and they can examine bills and issues in parliamentary committees. You'll learn about this later on, but we can investigate laws before we pass them, and public approval for those laws, whether the public really wants them or not, and how effective they're likely to be, by the government initiating an investigation, and really a couple types of investigations into them. Um, During this process, it's a thorough investigation, and a report is generated and tabled in Parliament and presented to Parliament. Based on that report, they can decide what the best course of action is. However, they have no obligation to commit to anything. So, just how they form government, this also includes representative government because directly chosen by the people. Remembering that from the Constitution, we'll have more of a look on that. So, the upper houses, as we discussed, it is the Senate at the Commonwealth level, and at Victoria level, it is the Legislative Council. So, what does the upper house actually do? Well, there's a lot of overlap. We see some of the same things, acting as a house of review, reviewing laws. We know this is more the upper house's role than the lower houses. Scrutinizing government also more commonly happens in the upper house than the lower house. They can also examine bills and issues in committees, though this is more likely to often happen in the lower house. Um, and remembering the clear differences. So they cannot initiate money bills. They will still vote on them. So if the lower house initiates a bill related to money or government spending, it will pass through. The senators will still be voting on that bill. It's just that they can't initiate it. And they also, rather than how the lower house directly represents the people, because they're directly chosen by the people, so therefore forming representative government, instead, the upper house represents the interests of the states and regions of Victoria. Just remember how it's composed. 12 senators are chosen from each state and two from each territory based on broader sort of geographical regions. So instead, they represent the interests of distinct geographical regions or electorates, as we call them. And this is very different to the House of Representatives, where people just vote for members. And this is supposed to be a good thing that we have the House of Reps representing the people versus the upper house. We have senators representing the interests of the states. But in reality, we know that that's not really true because all of them belong to some kinds of parties. So essentially, that function not fully fulfilled just because they're still party members. So it's not as much interests of the states as much as it is interests of their respective parties. Um, Having a look next at the roles of the crown. Essentially, when we talk about this, we're talking about what does the governor general do? Because the crown is represented by the governor general. So it's not actually the monarch, not the crown, doing all of these things. We have a constitutional monarchy in Australia, which means that we have a constitution and we have a monarch, the crown, very self-explanatory, good term. And the crown is the head of state, and it has its representative at state levels and Commonwealth levels. So the governor doesn't have this excess of power. They have certain roles that they fulfill solely just as part of representing the crown. So that's a common misconception that some students have, that the governor general has this like infinite power. Um, so what does the governor general actually do representing the crown? Through the passage of bills, the last step is when it passes both houses, and during the vote, more than 50% of each members, both in the lower house and the upper house, say yes to the bill. There is a last step called royal assent. In this step, the proposed law, actually goes to the governor general, and they have to give it like it's the royal stamp of approval so it can actually become a law and actually become part of legislation. If this doesn't happen, the law cannot be passed for whatever reasons they choose not to give royal assent. It might be just that some amendments are needed, and they might do the whole process again of trying to pass the law from the beginning, and it might get approved again. But so of course the Governor General, because they grant this royal assent, they can either grant royal assent or withhold it. This really doesn't happen very often or much at all. There would be some kind of reason for this. Um, there's something about the law just being probably viewed as really bad or against the interests of the country. Um, so when they grant royal assent, they just sign those bills as the last step, and then they can become part of legislation and law. Um, they also appoint an executive council. This is our government. So this is a formal step. So those uh, members of the lower house that had formed the majority of seats in the lower house after an election, they will be appointed as the executive council by the governor general, meaning simply that they will have executive powers, which we will also look at later. This essentially means that, yeah, the same thing. Party leader becomes prime minister, and they can select ministers for various roles in managing the country. The Governor General also appoints federal judges. So these are judges for the High Court, of course. So this is their role. So we can see already there is some overlap between judicial powers and the Governor General, which technically has both legislative and administrative slash executive powers as well. So this can be a bit of a disadvantage when we talk about it later on. And they can also dissolve parliament. So what does this mean? Obviously, re-elections in the House of Reps are every 3 years. However, what might happen is the Governor General might suspect that there's some corruption or bad things going on in Parliament, and they may choose to dissolve it early and have an early re-election. This wouldn't be, again, a thing that would happen often at all. This is almost like an emergency power held by the Governor General. So we're kind of we're going to look at the division of powers, which is the very next dot point. We've literally already covered one of the dot points on the study design for Unit 4, Area of Study 1. Of course, in going into depth, you'd want to also be aware of the compositions of each house, how many members, how are they selected, and you also want to be able to draw um, the be able to discuss the strengths and the weaknesses or the limitations of the roles of each lower house, upper house, and the Queen's representative. So that's something to also work on. So next we'll have a look at the division of powers. These are the lawmaking powers that are given to Parliament to create laws. They are divided between the state parliaments and the Commonwealth Parliament. So when we look at separation of powers later on, it is really important that you can tell the difference between the two, because a question will just mention like division of powers or separation of powers, and if you answer based on the incorrect concept, you will not get any marks. So make sure you try to commit the names to memory and have strong links in your brain. So division of powers, how it's divided between the states and the Commonwealth. Separation of powers refers to how there's no overlap between judicial, executive, and legislative powers, or supposedly. And it's separated by the Constitution. So we'll have a look at that concept as well later on. Um, so this division of powers decides essentially, obviously we have states and we have the Commonwealth. So how do we know which parliament is going to have which powers? And it resolves this problem. So these are exclusive, concurrent, and residual powers. Having a look more in depthly, exclusive powers, the title is so self-explanatory. They are exclusive to the Commonwealth Parliament. Only the Commonwealth Parliament can legislate in these areas. The states can absolutely never legislate under any circumstances in these areas. Um, so exclusive powers are usually just specifically noted or entrenched in the Constitution that the Commonwealth has those powers. That's something else that you need to know. And examples of these include things that are very, very clearly only the country itself can do, such as defense, military, currency of the country, border protection, And of course, you might even say things like Commonwealth level, like criminal offenses. There's lots you could think of. You might think about export and import with other countries as well. So, of course, the Commonwealth can legislate there and not the states themselves, because the laws for the entire country would be in disarray. There would be no uniformity across the country. And if each state had its own military, we could have things like civil wars, and that would not be very good. Um, so, next we'll have a look at concurrent powers. Again, a very self explanatory title, which is very, very great. Concurrent is clashing. Both the states and the Commonwealth parliaments have powers in these areas, hence they're concurrent. Um, and this is where, so both the Commonwealth can legislate in these areas and the states can legislate in these areas also. So we'll have a look at Section 109 and the significance of it, because it essentially tells us what would happen if both parliaments made laws in the same areas and they contradicted. So, very important, because of course that is inevitably going to happen. So, what are some examples? Trade, taxation, and marriage and divorce. So, still have separate laws in states and Commonwealth parliaments for such things. So, makes lots of sense. So, trade, for instance, yes, we might have import and export, for example, laws in the states, like even between the different states, and then Commonwealth might consider the other countries, so international trade and export, and legislate in those areas. Taxation, you have some local taxes like council tax, um, and car payments, pet payments, but on Commonwealth level, everyone's income will get taxed the same, for example. So let's instantly jump into section 109 and look at its significance and what it does when we have concurrent laws. So this section of the Constitution states that when a law of a state is inconsistent with a law of the Commonwealth, meaning the two are clashing, the latter shall prevail and the former shall, to the extent of the inconsistency, be invalid. So the Commonwealth law will prevail or continue to operate, and the state law will be abolished or removed, essentially declared invalid, but only to the extent of the inconsistency. So only the aspects that clash with the Commonwealth law will be declared invalid. The rest of the law will continue to operate. So it's really important to understand that state legislation only becomes invalid to the extent of the inconsistency. This is the one thing that you should be able to remember off by heart and quote for section 109. You can state the section in your own words because you will have to describe it, but to the extent of the inconsistency is very, very key. So what does this section 109 do? It obviously gives more power to the Commonwealth and takes more power away from the states in terms of lawmaking. As you'll see later for Unit 4, this is an ongoing theme. Everything takes away power from the states and gives more power to the Commonwealth. We'll look at this when we see more high court decisions and more disputes that have come up. So we can see that there. Section 109 protects the Commonwealth, enhances their lawmaking power by allowing their laws to remain completely in operation, and it inhibits state laws' powers because it reduces them when there is a clash. So you need to be, that's the significance of Section 109, that you need to be able to analyze what it does to state powers, what it does to Commonwealth powers. Also, pretty fair that the state law can still operate only to the extent of the inconsistency is removed. So in reality, it can still operate. It's not so bad or so limiting. So lastly, we have residual powers. And these are the lawmaking powers held only by the state parliaments. Um, and this is generally everything that doesn't fall into the Commonwealth Constitution. So there is no sections in the Commonwealth Constitution that mention these residual powers. Therefore, by default, they are state parliament powers. So everything that is not exclusive, everything that is not concurrent, um, so essentially everything that isn't in the Constitution is a power that belongs with the states. Lots of examples here, probably the easiest to think of for your describe and explain questions for these division of powers, such as criminal law, education, and public transport. Just consider in terms of education, every state has a different education system. Similarly with public transport, that is because they have been able to legislate and create their own. It does not have to be by default the same across the entire country. Um, so it turns out to be the majority of lawmaking powers. This is a really good quote in order to keep in line with the purpose of the Constitution. The initial purpose of the Constitution, when it was established, because Australia was coming together as a federation and all of these states joining together into a federation, so it tried to reinforce this purpose of not taking power away from the states, but allowing them to retain as much power as possible without the Commonwealth powers interfering too much. Therefore, this is the majority of lawmaking powers are residual. So that's another dot point done on the study design. Next, we'll have a look at how the Constitution acts as a check on Parliament and their lawmaking powers, essentially trying to prevent corruption, trying to prevent Parliament from being able to do whatever they want, legislate on whatever they would like, and abuse their powers and even go above and beyond what's in the Constitution and go directly against it. So, Constitution protects us against this by several things that it establishes. This includes the bicameral structure of Commonwealth Parliament. Bi meaning two. Bicameral structure simply means there are two houses, a lower house and an upper house. So at Commonwealth level, our House of Reps and our Senate. Then the separation of powers, the one that is not to be confused with the division of powers, the express protection of rights. These are 5 rights that are entrenched or written down in the Constitution that are protected for the people of the Commonwealth, and the Commonwealth cannot legislate against them. They are ensured for the people and offer some protection. We have the role of the High Court in interpreting the Constitution. We'll look at quite in detail, and the requirement for a double majority referendum, making referendums very difficult, making it difficult to change the Constitution, and therefore protecting the people because the Parliament isn't able to alter any protections that we have in sections of the Constitution without our support. So having a look at the bicameral structure. Like we established, this refers to a structure that consists of 2 houses of parliament. So both state and Commonwealth parliaments follow the bicameral structure. But what's key to understand, and you can say for these evaluate questions you will have for this mini area study, evaluate questions, right? So that is a bit of a weakness because if it's in the Constitution, it's not in state level legislation. So state parliaments can actually have a one house structure if they want. And we see this in Queensland. This offers less review for laws, obviously, and that can be a disadvantage. So the bicameral structure is only assured at Commonwealth level, and this is a weakness. So under the Australian Constitution, Section 1 that you need to know about, it is Section 1 that establishes that there are 2 houses within the Commonwealth Parliament. Not one, but 2. And then we know in more specific detail, Section 7 and 24 establish the Senate and the House of Representatives and all of their roles. We will also be having a look at those sections. So having a look at the bicameral structure, what are some strengths and some weaknesses? Of course, a strength is that it is entrenched in the Constitution. So this protection cannot be abolished or removed without a successful referendum. It also ensures that each bill that is passed is scrutinized and debated by the 2 houses, making sure that we have a process for reviewing our laws before they are passed, not just one house that can just pass laws through because it's what they want to do for whatever interest that they have. This also enables us, the aspect of reviewing laws, to identify errors and omissions in bills and make amendments or changes to issues that have come up with laws. Of course, there are some limitations also. So the three structures that you need to know about for the bicameral structure are the hostile Senate, the rubber stamp, and the rubber stamp acts as a huge limitation as well. Essentially, this is not common at all, but sometimes the composition in the Senate will be similar to the House of Representatives, making it a rubber stamp Senate. It will just stamp on laws, give them a passive approval, and they will pass on and become legislation. In this case, the major majority of seats, the party that's forming government in the lower house, they also have the majority of seats in the Senate. And they have more than 50% of people, so they can just approve those laws and get them passed. Of course, this is a huge, huge disadvantage. Um, what we really want is a hostile Senate. And this is the structure that we usually have. Again, another term that you need to know. Why is the Senate hostile? Because they have a different composition from the House of Representatives, meaning the major government party is not the majority of the senators there. So laws can't get passed unless the government party is trying to get the approval of the senators and all the different parties that are there to get that 50% of votes plus. Um, and then, of course, last structure is a hung parliament. It is hung because it struggles to pass laws and it is very slow to pass laws if it is still passing them. In this case, there is no one single major party in the House of Representatives. There is no one major party forming government and being able to pass laws alone. So those are the three structures to know of. Some more limitations that, as I discussed, the structure is not entrenched. It's not in the constitution for Victorian or other state parliaments. That's why Queensland can have a parliament with one house. The lower house is controlled by government, and therefore laws are generally only passed if they are supported by the government. That is a fatal flaw in the bicameral structure, is that the government has way too much authority and they are able to pretty much do all of the lawmaking until the next election if the composition changes. All right, that's the bicameral structure done. Next, looking at the separation of powers, reminder not to be confused with the division of powers. Um, the separation of powers you need to be able to define. It's a principle established by the Commonwealth Constitution that ensures that the three main functions performed by the Australian parliamentary system remain completely separate. So we have executive power, legislative power, and judicial power. In theory, these are supposed to be separate, but they overlap. So executive power is essentially administration of laws and managing the business of government. So how laws from when they come into legislation are actually put into effect. And a lot of the work in relation to this is done by that leading that representative government, that majority of seats in the lower house, because they have executive powers. They have all the ministers, they have a lot of power, and therefore you can already see they're in parliament creating laws and they're also administering the laws. So there's a significant overlap between executive power and legislative power, and that could mean lots of things. It could lead to corruption and abuses of power, etc., etc. So, of course, legislative power is the power to make laws. This is our upper and lower house. And of course, the Governor General, who's representing the Queen, fits into both executive and legislative power. Legislative, why? Because they give or withhold royal assent to pass a law. Executive power, they literally appoint the executive government, and the judges also, they have lots of power. Judicial power is the power to enforce the law and settle disputes. When we're talking about this, we're more so talking about the High Court judges being able to do this at Commonwealth level and regarding the interpretation of the Constitution. Now, in theory, this is kept pretty separate. The Governor General technically represents both executive and legislative power and overlaps with judicial power because he appoints the High Court judges. However, in theory, this is not much of an issue. Um, it's not likely to be many problems arising from this because it's more of a formal step. So inferior judicial powers kept pretty separate, and you can discuss that as a strength for your evaluate questions. So again, just a reminder not to confuse the two. Try to make it easy for yourself to remember somehow. I feel like separation and division kind of have different connotations, and it sort of makes sense. So, what are the strengths and limitations of the separation of powers? Again, this is a recurring point that you will see for all of the five checks on Parliament. It's entrenched in the Constitution. So we cannot abolish the separation of powers also without a successful referendum, which is never going to happen because why would we remove our own protections that we have for ourselves and set ourselves up to really fall at a disadvantage where the Commonwealth could remove these checks. It allows for the executives to be scrutinized by the legislative power holders. So, considering that um, people administering laws and managing government will be scrutinized by members of parliament, especially this happens in the Senate, saying that they're doing things wrong, they're not administering laws effectively that have come into power, etc., etc. This obviously sparks a lot of media attention, and they may legislate to change some of these things if they do so successfully. The problem here and the disadvantage that comes from this is that the legislative and executive powers are combined, as we said, by that government, that representative government of the time. So this really decreases the ability of this to act as a check on the separation of powers. And there's not as much scrutinizing going on, except maybe more so in the Senate if it's not a rubber stamp, because in the House of Reps, it's that a representative government that has the majority of the seats, and they can just pass things along. So that can be a bit of a flaw. If there is problems with executive powers and things need to be changed, legislative powers may struggle to enact any real change or not want to do so because of that executive government being in parliament. Also, judiciary powers, we can quite well say, are very relatively independent from both parliament and the government, and executive and legislative powers, meaning that judges will should always interpret the Constitution in a just and correct way and have the people's best interests at heart and not do things that benefit the Parliament and government. Um, Also, some other weaknesses, we already discussed the first one, but we said that judges are appointed by the executive, so are obviously our Governor General acting as a representative of the Crown, and this can be not a good thing, I guess, if the Governor General has some subconscious biases and stuff. Judges are also protected because they cannot be they have a very late retirement age and they cannot be removed from the high court unless there's some evidence of corruption and unlawful behavior, which is very difficult to then prove. So they are protected once they are appointed. Another limitation is, again, you'll see this throughout, the Constitution only provides for the separation of powers at a federal level, not state level. So the next thing that we need to have a look at is the express rights. These are also known as explicit rights. If you see that, it's just a synonym. You need to be able to define them. Don't use the word express in the Constitution because that is the same word as the word in the actual term. So you can say that they're specifically entrenched or listed or enumerated or stated in the Constitution. Entrenched and enumerated are stronger words, however, to use. And there are only 5 protections that we have under the Australian Constitution. So you need to know all of these. You could even have a 10 marker where you have to discuss all of these. More likely so, you would have a 10 marker to evaluate all of the ways in which the Constitution acts as a check on Parliament. So be prepared for that. Have good knowledge for all of these dot points. So what are the five express rights under the Australian Constitution? It is the right to freedom of religion, which is our section 116, which we need to remember. Essentially, the government cannot impose laws interfering with religious practices or declare that one religion is the religion of the country, which offers protection for people to have a variety of religions here and nothing to interfere with their practice. The right to free interstate trade and commerce in section 92. You do need to remember the sections. This is very straightforward. The title is self-explanatory. It means that the states can trade and have import and export with each other for free, and cross borders for free. The right to receive just terms when a property is acquired by the Commonwealth in Section 51 and subsection 31. That's what XXI is, subsection 31. This means that the Commonwealth can take your property from you, but they must provide you with just terms. So, think of that what you will. That is extremely broad, meaning the Commonwealth could easily get around it. But think of things like giving sufficient time to vacate, giving some financial compensation, or offering maybe alternative housing, things like that. The right to a trial by jury for indictable Commonwealth offences in Section 80. This is the one that you already know about because you studied the criminal justice system in Unit 3 Area of Study 1. So that should be nothing new. Keep in mind that this is only for Commonwealth level offences, not state level criminal offences, Commonwealth. So we're looking at some more serious stuff like fraud and terrorism, things like that. Not Therefore not used as often, this power. So the right not to be discriminated against on the basis of the state where you reside is our last one, section 117. Easy to remember because it just follows on from section 116. Essentially, residents of other states cannot be discriminated against, whether that's verbal, whether that is a form of you're trying to move and no one wants to hire you for work, or uh, give a contract for a tenancy for you, or they try to make things more expensive for you. It could mean lots of things, but essentially every resident of every state in Australia can be a resident in another state. They just have to move, do some paperwork. There's no discrimination for them. They can be a resident of any state that they like. They can travel around the country, etc., etc. So lots of things go into that. Again, very broad. That is a limitation of all of these express rights. They are broad. There have not been many disputes where these express rights have been brought to the High Court. Therefore, it is unclear even in which circumstances what the Commonwealth can do, cannot do, what is a breach of an express right, what isn't a breach of an express right. That's a big overarching limitation. Similarly, if a person's rights have been infringed, they have to have lots of money and funds to initiate a High Court case. So it's going to be very expensive to take a claim to the High Court and potentially also time consuming. Much more so than if you're thinking like, is it like the Supreme Court? It's much more. So another problem with that is you can just take it to the High Court. They will, if they do agree with you, they can just declare a law invalid, or say that someone has to stop, doing this kind of action against you that was infringing your rights, kind of like almost an injunction type thing. But you cannot get any monetary compensation, any damages in the High Court. There is no compensation. You're pretty much just going there to have a law declared ultra vires or invalid. So this is really problematic and makes a lot of people unmotivated to bring their claims to the High Court where express rights have been infringed, for instance. Similarly, to try to protect express rights and breaches of express rights, an individual has to have standing, meaning that they have to be directly affected by that law's operation. It has to have directly impacted them in a negative way. I can't just be an interest group or someone who believes in pursuing like human rights, and I can't just take a claim to the court, even if I have the costs, and even if I have the best interest in mind. only people with standing who are directly affected. That's lots of limitation to whether these express rights are actually attempted to be questioned. And rights that are protected, as we said, are limited in scope. It's very broad, lots of ways for the Commonwealth to surpass them. Not enough disputes to define how they actually work, and all the exceptions and things that would apply and still serve as a protection for those rights. Similarly, not really applying at state level. Another limitation that we've been seeing constantly, for example, just indictable Commonwealth offences, not state level offences, Section 80. What are some strengths of the express rights? They're again entrenched in the Constitution, so they cannot be abolished without a referendum. If a person believes that a law is infringing upon these rights, they can take a case to the High Court. So once we've discussed the limitations, the strengths are very easy to understand. And a High Court case can act swiftly in declaring a law ultra vires, meaning beyond the powers of Parliament, meaning invalid. This is a term that you need to add to your vocabulary also. So next, we'll have a look at the role of the High Court, which will be easy to understand after just discussing express rights. So Section 76 of the Constitution gives the Commonwealth Parliament the power to provide the High Court with jurisdiction to hear disputes involving the Constitution. So you will learn about the jurisdiction of the High Court in more detail later on. For now, you need to understand that under Section 76, the High Court can hear disputes involving the Constitution, including the interpretation of the Constitution. So the implications of the words in the Constitution, what is implied by the Constitution. Might be thinking about the implied right to freedom of political communication already, and we will be and that is one way in which the Constitution, just the one that we have actually, has been interpreted to define an implied right. So the fact that the words in the Constitution say directly chosen by the people in terms of the government should mean that we have the freedom to politically communicate, and that was defined by a couple of cases, famous cases. Later on, you'll learn that the High Court also has more jurisdiction than this, and that includes resolving disputes between different states, resolving disputes between a state and the Commonwealth, resolving disputes between actual individual people from different states as well. And there are some more, like them potentially choosing to hear a case because of high media attention and the need to hear it. Maybe after it's been appealed from the Supreme Court, they might still take the case on if it's very significant and has raised a lot of public discussion. So the High Court cannot change the wording of the Constitution, of course, even if they broaden out a law and they say that, oh, these are exceptions, and in this circumstance, actually, you're right. The express right implies that you would be able to do this and pass this law. They can't add that in. They can't edit anything, but they can develop common law around it, judge-made law around it, develop more legal principles, develop a doctrine of precedent, and they can give the words meaning through that interpretation. So other disputes will be resolved in a similar way in the future. So what are some strengths and limitations? Of course, judges are independent and they can make decisions based upon legal principles rather than political pressure. And because they're so independent, they don't care about the political pressure, or they shouldn't care about the political pressure. And we have an unbiased lawmakers reviewing constitutional matters and matters regarding constitutional interpretation and making just decisions based on what they think the Constitution actually intended. The existence of the High Court also allows for laws to be overturned if they're found unconstitutional. We're talking about ultra vires here. They're declared beyond the scope of Parliament's powers and therefore invalid. And it acts as an independent check on abuses of power, not allowing this to happen. Of course, they are not proactive, they cannot take action, they are reactive. A case has to come to them so that they can rule on the facts of the case. So they can't even act as a check on an abuse of power until someone with standing and the money to initiate a claim comes along, and there is a case that they can rule on and make a decision. And of course, this means that oftentimes some laws are not even changed because no one cares that much about changing them, or just it might be taking a very, very, very long time to enact some real change. So the decision may depend on the composition of high court justices as well. We know that they can have things like preconceived biases and views and things like that. Um, and they can only interpret the constitution and determine whether parliament have abused their power. They cannot change the wording. So all of it is interpretation, and none of it actually goes into the constitution, as I mentioned previously. Lastly, we look at referendums and the requirement for the double majority. This is another section, surprise, surprise, of the Constitution that you have to remember, section 128. It sets out the process of a referendum, and a referendum is essentially the steps that have to happen in order to change the words of the Constitution, whether that means taking some sections out, or changing, or editing, or adding two sections. Any change to the Constitution has to go through a referendum process. But for a referendum to even be successful, every referendum question has to satisfy the double majority provision. So if the referendum has 5 questions on it, this double majority requirement has to be satisfied for all of those questions. So that's why we want to stick to 1 or 2, because it's already so difficult to achieve. So these are that the majority of voters in the whole of Australia, including the territories, must vote yes. I simply think that's easier to remember as more than 50% of Australia's entire population have to vote yes. And the next one, a majority of voters in a majority of states, excluding territories, have to vote yes to the proposed change, meaning we need to have more than 50% of voters voting yes in at least 4 out of the 6 states in Australia. Remembering territories are excluded from this. Additionally, if a state is directly affected by the proposed change, they also need to have a majority of voters in that state for the referendum to be successful, and added third requirement depending on the circumstance. Of course, this does not happen often at all, because the referendums are so rare themselves, but it serves as a protection to small states. If the legislation affects them directly, of course, a majority of people should be voting yes as well to demonstrate support for that change. So in Australia, we've only had 44 referendums, and only 8 of them have been successful. Why? Because this double majority requirement is so, so, so difficult to achieve. And it's very time consuming process. It's a very expensive process. So the Commonwealth only tries to do this when they're really sure that there's a lot of public support for a law. We will look at one referendum today. So you need to be able to understand the double majority and be able to define the double majority requirement. What is a referendum? What is the relevant section? And you might even you might even get lucky and get a very easy question on the exam where you have a table with like referendum votes in different states and across the country, and you have to interpret if the referendum is successful. So it is crucial that you understand these types of questions. It was a 4 marker in 2020, essentially free 4 marks. You could easily achieve all the marks just by applying the double majority requirement to interpret some statistics. So make sure that you know this area very well. Also, because you have to study an example of a referendum. So what are the strengths and limitations of the double majority requirement? Obviously, it provides the power to the people. So the constitution that is intended to protect them, it cannot be changed unless they want this. A majority of them want this. Parliament cannot do anything to change it. It is completely protecting the people. The vote is compulsory, so everyone has to vote and demonstrate an opinion and respond to the proposed change. And also that the process is very, very long and it requires information to go to voters about the proper change. This ensures that voters have a lot of understanding around the referendum and what it entails, and they are able to make an informed vote, an informed decision. So Parliament is required to do this over a certain extended period of time, this entire process, and they are actually required to ensure that there is a lot of public information being released about what the referendum is about. Then, of course, you have media attention, etc., even increasing the amount of information that is available and being spread around. In terms of limitations, so the public might not understand the complex details of the proposal. Um, we know that unfortunately, a lot of people across the country do not have um, much legal literacy or even take an interest in the government, unfortunately. And statistics have shown that these people are more likely to just vote no to a referendum. If they're not sure, or if they don't know, or if they distrust the government, um, they're just likely to vote no. Of course, that makes the double majority requirement even more difficult to achieve if we have all these people doing this just because they're not sure. So leading into the next limitation, that the double majority is difficult to achieve. As you might predict, it is the second requirement that is very, very hard to achieve, not as much as the first one, a majority of voters in a majority of states. More than 50% in 4 out of 6 states. That means only 2 states can have anything less than 50%, so making it very difficult. And the fact that they're timely and costly for the government. So they're not going to do this process except when they're really sure that it needs to happen and they need to have an attempt. They cannot have referendums constantly to make sure that the constitution stays up to date with changing values and changing times. Amazing. So the next thing that we'll have a look at is Section 7 and 24 of the Constitution that we already had a quick chat about. You need to know these sections also. We said how Section 1 establishes the bicameral structure, two-house structure of Parliament, but Section 7 and 24, they establish each house individually. So Section 7 sets out matters related to the Senate or the upper house. This includes, of course, their composition, that they're supposed to be about half of the number of the House of Reps. So the composition is halved, like they have half the amount of members. And of course, their roles and the things that they can do. Similarly, Section 24 does this for the House of Representatives and sets out an important quote that it's directly chosen by the people of the Commonwealth and that it's twice the number of the senators. And again, their roles. So there is a case that you are required under the study design to know with regards to Section 7 and 24. It is called the Roach Case. And I have a really great breakdown for you as well of what was happening in this case, also, if you haven't studied it yet. So Vicky Lee Roach was serving a 6-year term of imprisonment. So Vicky was actually convicted and was enrolled to vote in the seat of Kooyong, like vote for elections. And in 2006, the Commonwealth Parliament passed an act or a law that banned all sentenced prisoners from voting in elections. So Roach couldn't vote anymore. And there was also a previous 2004 act that said that prisoners, if they were serving sentences longer than 3 years, they could not vote. However, the 2006 act extended this ban to all prisoners not being able to vote in elections, even if you were in for a pretty minor offense. So Roach was upset about this and challenged the constitutional validity of these acts and took it to the High Court. Not sure how Roach had the funds for this, but very interesting, very noble. And this challenged that law that the Commonwealth Parliament passed. The High Court actually declared in Roach's favor because they found that the 2006 Act was inconsistent with Section 7 and 24 of the Constitution. Remembering that very important quote, why was it inconsistent? Because parliament needs to be, quote, directly chosen by the people. If we ban all prisoners from voting in elections, it doesn't represent all of the people anymore, does it? A significant amount of the population would not be able to vote. Um, However, the High Court also ruled that the 2004 legislation was still valid. So they're scrapping the 2006 law, but the 2000 law remaining in operation because prisoners sentenced for more than 3 years were viewed to have committed more serious crimes, and it was fair to exclude them from voting in elections. That was the decision. Of course, that means that a much less significant number of prisoners is then excluded. Because if you think about the volume of people that are serving sentences less than 3 years, it is much larger than the volume of people serving longer sentences. As we know from the criminal justice system, just think about how many more claims go to the magistrate's court than everywhere else, therefore, summary offenses, as an example. So, same thing with prison terms. A lot of people committing some less serious offenses. So, what happened to Roach? Roach had a small victory because the law was declared invalid, the 2006 Act. However, Roach was serving 6 years of imprisonment, and Roach could not vote because the law was if you're in prison for longer than 3 years, you cannot vote. Amazing. So then let's look at the one referendum, as you do need to know a successful referendum as per the study design. And we will look at the famous Aboriginal and Torres Strait Islander people's referendum. Remember again, you need to know it in pretty much this level of detail that you're seeing on the slides and be able to discuss what happened, how, for example, Section 7 and 24 served as a protection in the Roach case, why it was interpreted that way, how is that significant. Same for the referendum for Aboriginal and Torres Strait Islander peoples. Um, Up till 1967, so this referendum happened a very long time ago, there was some very unfortunate sections in the Constitution with regards to Indigenous and Torres Strait Islander peoples. The Constitution was denying the Commonwealth the power to legislate for Indigenous peoples, so literally limiting them from being able to make any laws around Indigenous peoples. They would not be able to make laws for the benefit of Indigenous peoples, for the protection of Indigenous people, and essentially to treat them as part of the population. They were even referred to as flora and fauna on the Constitution. Very, very awful stuff. And of course, when the Constitution, was published in 1901, when those colonial awful views were still a large part of the society. Therefore, the Constitution reflected those views, unfortunately. So, the second aspect, so not legislating for Indigenous people, and they would not be included in the national census. So they can't vote. They're not counted as part of the population, even. So they're not counted as part of the population. The public sparked a lot of discussion around this and believed it was really unfair and that these sections of the Constitution had to be scrapped. And therefore, a referendum was initiated in 1967. And they had two questions on the referendum. So, should Indigenous people be counted in the national censuses? And should the Commonwealth Parliament be allowed to create law regarding people of the Aboriginal race? You need to remember sort of the questions or in your own words, and it's quite easy because we know what the referendum is about. And the results were amazing. It's the most successful referendum that Australia has had with the most support. It was a strong 91% majority voting yes across the nation. And the double majority provision was also highly, highly successful. Victoria, I believe, had the highest vote in terms of states individually, something at high 90 something percent. So therefore, the Commonwealth Parliament now had the power both to legislate for Indigenous people and to include them in the censuses. And to do this, they changed Section 51 of the Constitution and Section 127. So, say changing 51 and 127 allowed to legislate for Indigenous peoples and include include them in the national census. sorry, Section 127 was deleted entirely, where it just said that they wouldn't be included in the national census, and Section 51 allowed to legislate for indigenous people because of the alteration. So remember what happened to the sections as well. And we'll look at a case in relation to the division of powers as well. So, remembering division of powers, how are the powers divided between the states and the Commonwealth? Not to be confused with the separation of powers. So, this is the Brislin case. It's with regards to Section 51 of the Constitution, which gives the Commonwealth power to legislate with regard to postal, telegraphic, telephonic, and other like devices. That section could use an update these days, but that's what it says. So, with regards to technology, and Commonwealth Parliament's Telegraphy Act in 1905 said that all owners of radios had to hold a license. And this individual, Brislin, had a wireless receiving set for about a week and didn't have a license and was charged with, of course, an offense. And Brislin decided to challenge the constitutional validity of the Telegraphy Act 1905. So, what was the outcome of this case? The High Court interpreted that other like devices, of course, would include broadcasting to wireless sets. Because this technology wasn't around at the time, literally, you can view this part of Section 51 as quite literally just stating legislate with regards to ownership of various technology, right? And communications. So, it didn't make sense because Brislin brought this to court thinking that um, the wireless receiving sets were not specifically mentioned in that section of 51. And that was, of course, false because it is just a broad, it's intended to be a broad law. Other like services makes it broad and open ended. And by adding broadcasting to wireless sets to the meaning of this legislation, of course, into common law and not actually changing the constitution, the Commonwealth Parliament's power was extended because it shifted lawmaking powers from the states to the Commonwealth. So another example of the Commonwealth Parliament's powers are increasing and the states' powers are decreasing. So Brislin might have thought that the states should have this power, not the Commonwealth. However, this was another instance in which the common law expanded the Commonwealth lawmaking powers and simply just validating that Section 51, yes, this is a power of the Commonwealth. The Telegraphy Act 1905 is valid. So that's a bit of a less interesting case, but still one that you would like to know for the division of powers and be prepared for. The referendum and the Roach case otherwise are very, very easy to remember. Okay, so and we're close to the end of the first half, but we'll look at external affairs as well. Recognize Section 51 again, but the subsection we're looking at now is 29. XXIX 29, subsection 29. This subsection gives Commonwealth Parliament the power to create laws in relation to external affairs. Now, what does that mean? You need to be able to define it. It is a power that enables the Commonwealth Parliament to pass legislation reflecting international agreements that Australia is a part of. Simply, if Australia makes an agreement with another country, such as a international treaty or declaration, they now have the lawmaking power to pass legislation to reflect the agreements that they have signed to. Previously, this was unclear because the section, right, just says external affairs. High Court interpretation has established that yes, external affairs does include enacting treaties and declarations, signed agreements with other countries into legislation. So that's what the statement says. It's interpreted by the High Court, so interpretation of the Constitution happening yet again to include information found in international treaties and declarations. Essentially, this means that the Commonwealth Parliament has the ability to legislate on treaty topics, even if they're not in the Constitution or not under their lawmaking powers. For example, if some of the agreements of a treaty or declaration Australia has signed to fall under residual powers of the states, because the Commonwealth Parliament has external affairs power, they can still legislate in areas of residual powers. Do you see the common theme? Again, reducing, taking away power from the states, increasing the power of the Commonwealth through interpretation of the Constitution. Happening yet again. And that is a recurring theme that you will continue to see in Unit 4. This is not hopefully difficult to understand. Another section to remember, another definition to remember. Important to take into account that they can legislate in residual powers. That is actually very important because often some agreements and treaties and declarations do require that. So, to talk about this external affairs power, we will look at a specific case, the Commonwealth v. Tasmania case 1983. You want to refer to it in exam questions under its proper name. Also, it's commonly referred to as the Tasmanian Dams case. So we'll have that subtitled there. But remember to refer to it as Commonwealth v. Tasmania. It's the more appropriate way to phrase it, the actual name of the case. So why is it called the Tasmanian Dam case? It's because it's with regards to an actual Tasmanian dam. So this is one that you can be assessed on. So let's have a look what happened. Essentially, the Tasmanian government intended to make hydroelectric power source, water power source, by damming the Franklin River in Tasmania. And they passed an act to establish a law so that they could do this. But there was a lot of public outrage and protests happening as a result, and it caused the Commonwealth Parliament to intervene, even though this was an area of residual power. So damming a river would normally be considered a power of the state, not Commonwealth. So after Tasmania passed their act, despite the outrage, the Franklin River was placed on the UNESCO World Heritage List, which in 1982, and this was also an international treaty. So it was determined to be a protected area on the heritage list, and an international treaty to protect, of course, World Heritage items in the respective countries. So this is now falling on Australia, where they're saying this is supposed to be a protected body of water, but I have states exerting residual power to dam it, to dam the Franklin River, and therefore impacting our ability to uphold the international treaty that we have signed to protect items that fall on the UNESCO World Heritage List. So the Commonwealth passed an act stating that the dam could not be constructed because the river was on the World Heritage List. And now we have two different acts going against each other, the states versus the Commonwealth, completely conflicting. So Tasmania was not happy with this because they're obviously thinking, so the Commonwealth is trying to overpower me and prevent this construction. And they took it to the High Court and argued that the Commonwealth passed law in an area of residual power, so meaning it was unconstitutional. And you'd think that's not too bad of an idea because that kind of makes sense. Remember that this external affairs power was not defined at the time. But the Commonwealth argued that they had this external affairs power, the Commonwealth, and the Commonwealth had authority to legislate in areas that related to international treaties, even if this interfered with residual powers of the states. So, because the Franklin River was on an international treaty, it came under the external affairs power of the Commonwealth, and therefore their legislation was valid. Seeing another concept, decreasing the power to legislate of the states, increasing the power of the Commonwealth to legislate, again, through another interpretation. So that is what happened in the case. And we see that here. High Court interpretations always getting in the way of the state's powers. Good conceptualization, hopefully. So what is the significance of the Tasmanian Dams case? You need to be able to comment on this. It impacted the Commonwealth by obviously giving them more power in this area over the states. Therefore, the residual power of environment in that specific area of legislation with relation to environment, it was reduced for the states, and Tasmania was unable to build their dam. But the external affairs power helped the Commonwealth to extend their power, again giving them greater power with regard to lawmaking over the states. And we see that there. Section 51, subsection 29, external affairs power, preventing a lot of laws from being declared ultra vires or invalid that are made by the Commonwealth because of this protection that they have. Amazing. So we've covered all of Unit 4, Area of Study 1. As you notice, we're taking a bit longer to go for that area of study because it's the one that you're doing at the moment. So you want the detailed explanations there. And we'll go a bit faster in Unit 4 and Area of Study 2 and look at a bit less content. So in less detail to make sure that you guys can understand everything. But something you'll notice, and this is amazing for you because, you know, when you go back to school, this is what you'll be working with, that there are way less dot points for Unit 4 Area of Study 2. You will very, very quickly skim through this area of study, and before you know it, it will be exam preparation time leading up to your exams. It will go by really quick, Unit 4. Um, and yeah, so you can see some additional things that you need to know about. We'll talk about most of these dot points there, and including law reform. However, some additional research that you will have to study up on and you will be assessed on individually as well is one recent example of the Victorian Law Reform Commission recommending law reform. So we'll look at the VLRC in a broad way, but you will actually have to have a recent recommendation of the VLRC and be able to discuss it and evaluate it, and give examples of what it was about. Similarly, um, you need the role of one parliamentary committee or one royal commission, and this is where the study design allows you to choose whether you want to study roles of parliamentary committees or royal commissions. So you actually get to choose. I personally studied royal commissions, and I found it was more interesting to me than parliamentary committees. But it probably will depend on what your school has decided. I do know royal commissions to be a bit more common and popular. Um, so therefore, you will choose which roles you study, either the parliamentary committees or royal commissions, and you will have to give a recent example of a recommendation, either by a parliamentary committee or a royal commission. So again, you will choose. You will only study royal commissions or parliamentary committee and give a recent example for only one of them. So if you get a question on the exam, it will tell you that you can use parliamentary committees or royal commissions as examples, and you will focus on one. So this reminds you of all the reforms, recent and recommended, you had to do for Unit 3. The journey continues, just like how you need to know about reforms, you need to know about reform recommendations, because basically these are what they are. Um, so that will take you to the end of the year. And the key skills, again, remember that you can use them to write up questions for yourself, and they are very, very useful. They tell you what you will be assessed on, what types of questions. So we're going to look at a lot of these concepts through a broad lens. We'll start by talking about the factors that affect Parliament in lawmaking. And these are the roles of the Houses of Parliament. And nothing new, we looked at the roles. The representative nature of Parliament, political pressures, and restrictions on the lawmaking powers of Parliament. So these are the 4 key things you need to remember, and we'll go into a bit more detail about each. So the first point, the roles of the Houses of Parliament. We already looked at them at the beginning of the slides if you want to rewind, but consider the effectiveness of the lower house in the circumstances where we do form a majority government. We know that that is beneficial. That is going to increase how much Parliament can make laws until the next election. If we have a majority government, they can quickly, bring up bills and pass them through and vote for them and easily make them become law. But if we have a hung parliament where there's no majority government, no majority party in the lower house, we know that law passing will be very, very slow, because the party that still has the majority of seats, they will have to get the support of other parties in order for their laws to pass through and become acts. Similarly, um, we also need to consider the effectiveness of the upper house. And there are two structures that we have also studied that we need to know of here. The rubber stamp Senate, that remember just gives its stamp of approval to every piece of legislation, very good for Parliament's lawmaking. They will get lots and lots of laws passed. So it enhances their lawmaking power. Um, and this is where we said Senate has a very similar composition to the lower house, meaning the government party is also has a large number of seats in the Senate. And then the hostile upper house, which is what we usually have, where the composition of the Senate is very different. Laws will not get passed through quickly. When they reach the Senate, senators will ask for amendments or may just disagree with certain laws that the government is trying to pass, therefore decreasing Parliament's lawmaking power. Of course, there are good things and bad things that come from this. We probably want to decrease their lawmaking power a little bit, right? Such as with the hostile upper house, where they can still pass laws effectively and everything is good. We don't want to decrease them too much, like a hung parliament, because it might not even laws might not even get through the first house, and we will not have legislation coming through when we need it. Um, and next, looking at the representative nature of parliament. So we know that Parliament, we have representative government. They are intended, especially the lower house, to reflect the views of the majority because they are the people who have voted them in, thus directly chosen by the people. And there are regular elections that ensure that Parliament remains representative, said House of Reps every 3 years. So the fact that they're directly chosen by the people and the fact that there is regular elections aims to ensure that Parliament remains representative and they reflect the interests of the people in their lawmaking. But there are some limitations with regards to this, including popular laws, reluctancy, and difficulty in predicting the future. What is start with the easiest reluctancy? Parliament may be reluctant or hesitant to make laws if they are controversial. Even if a large group of the population want those laws, it will cause controversy with other groups and it can affect their votes, so they might not be passing laws that are controversial. There are also, with regards to popular laws, laws that are popular with many groups will likely get passed on very quickly by Parliament and they will try to enact them into legislation. However, these can disadvantage minority groups and other groups that are not supporting the laws very significantly. And we have difficulty in predicting the future, kind of self explanatory. We don't know what kind of laws we're going to need. Parliament may not be able to make very effective, very relevant laws all the time because circumstances often change. And it's difficult to keep laws effective and up to date. So not going into these in too much detail, but these are kind of key points on these slides that you will actually look at in Unit 4 Area Study 2. Next, we have political pressures, and this is a very fun one because it's really simple. What are the pressures that Parliament has? And you have domestic, internal, and international that you need to be able to define. Domestic pressures in Australia. So people like individuals, organizations, or businesses could be placing pressure on politicians or parties to implement law and support law reform that suits them. That is what they want, especially if they're large corporations that have a lot of money and a lot of power. This might be a significant amount of pressure. Internal pressures are where the members of parliament themselves are feeling pressure to vote along party lines, even if they don't agree with what their party is proposing. And this is very very true because we often see all members vote along their party lines. And then, of course, international pressures, where other countries or international organizations, or even the pressure of things like treaties or declarations, could be putting on pressure on the politicians or government. And then we have restrictions on the lawmaking powers of parliament. We know about all this stuff already. Well, we haven't really looked at specific constitutional prohibitions, but we have division of powers, so ensuring that powers are divided between the Commonwealth and the states, and the Commonwealth can't legislate everywhere, and states retain the majority of legislative powers, still the majority of areas. You will also study specific constitutional prohibitions, what is not allowed specifically by the Constitution because it is in the Constitution, and challenging the law ultra vires. So people withstanding being able to, or even a state, challenge a law of the Commonwealth, and the High Court can declare it invalid or beyond the powers of the Commonwealth Parliament. Amazing. Hopefully that makes a lot of sense. This is a really good summary if you guys download the slides and or have access to the slides and keep them handy. This is a really good summary that when you do go into more in depth, you can use as your summary, like revision notes and things. And okay, so the next dot point that we'll have a look at is the role of the courts. We know that this is to hear cases and resolve disputes. We've already kind of established this already, but going into more detail, need to understand that judges sometimes are making law because they're deciding cases. This is common law. This is what I talked about, judge-made law, through determining disputes and imposing decisions. So you need to be able to define common law and define when common law is essentially made. When does it happen? If the court resolves a dispute where there is no existing law, there is no applicable law, so essentially they decide what the best principle to apply could be, and they might be using persuasive precedent, which refers to decisions in other countries or other jurisdictions, so maybe from a different state, that have been applied to similar cases. They might draw on those to decide, okay, I see what happened in England. Maybe if you remember the snail, the Donahue versus Stevenson case. That's an example of where we could use persuasive precedent for negligence. If you studied that in year 11. It's where there's no existing law, they often do take into account persuasive precedents from other court hierarchies where circumstances were similar, essentially what decisions were then made in that case. And they can also interpret statutes, so our acts or our laws, to apply them to the case before the court. So they can do the same thing that they can do with the Constitution. They can see what is implied within the law, even though it's not actually clear what the decision should be. They can see what was implied and determine that, and then create an outcome, such as with our implied right to freedom of political communication. And when a decision is made in the above circumstances, this establishes a precedent. So in this area of study, you need to know about precedent and the doctrine of precedent. And it is a very heavy, very important subject. It is a really important section of our common law system. It allows for judge-made law to actually operate and be effective. And it allows for consistency and clarity in how cases will be decided based on how prior cases and similar facts were decided by previous judges. So, when a dispute comes before a court, the court will first look to see if there were previous cases that dealt with similar facts and apply the precedent established in these. So, who has to follow the doctrine of precedent? All judges in all the courts that are lower than the court in which the initial precedent was established, where there is a similar set of circumstances. So, for example, say the Supreme Court establishes a precedent around some law that was vague, and they expanded that. And then the county court gets a case that is similar, and same issue. It's not really clearly stated in the law. We don't know how to interpret it. But then they know that the Supreme Court had a similar dispute, and they made some kind of decision in that case. And that case is very similar to the case that has come up for them. It involves interpreting the same type of legal principle. So, because they are a lower court, they have to follow the precedent. They cannot make a decision different to the one that was made in the Supreme Court. However, if the case went to the Supreme Court again, or a higher court of a similar nature, those courts that are higher in the hierarchy or at the same level, they are actually able to alter the precedent and alter that interpretation. And then that new interpretation will apply to all the cases in with similar facts and circumstances and whatever needs to be interpreted in all the lower courts. So if a precedent is established in the high court, for instance, it will apply to all of the court levels, all of the levels of the courts except the high court. The high court will still be able to change the principle if another case comes along requiring a similar interpretation. So that's the breakdown of precedent. And as you can see, of course, that allows for consistency and clarity. What is the purpose of precedent? Similar cases will be resolved in a similar way, ensuring consistency, ensuring clarity, ensuring fairness for everyone. So when it comes to the doctrine of precedent, there are key terms that you need to know of. Not just the doctrine of precedent. You need to be able to define that as well. And hopefully it's clear how to define that. It's that principle that cases will be decided in a consistent and similar way based on cases in based on previous decisions in previous cases by previous judges. So what are some key terms? We need to know about ratio decidendi. This is the Latin term meaning the reason for the decision. It refers to the reasons why the judge made a certain decision in a case, and it is the binding precedent. So all the lower courts will have to follow the reason for the decision, meaning they will have to impose the same decision and refer to the reasons for why that was the decision in future cases. Only courts on the same level of the hierarchy or higher than that court will be able to change this. Obiter dictum refers to, literally means by the way, and obiter dicta is the plural form. These are statements that are made by judges on points of law. So these are comments that judges will make with regards to a case. And it might be saying something like, oh, I am a lower court, but I really disagree with this ratio decidendi. I have no choice but to impose it, but here's why I disagree and why I think it should be this principle. It might change something, it might not change something. Or it could even be, say, with regards to criminal law, commenting that they think for this person it's not fair that the judge has to impose some kind of sanction based on law. So these are comments made by the way. This is how you can easily remember this term. They do not have any actual influence. They are quite literally just comments that the judge makes. So they do not form part of the ratio decidendi, and they are not binding precedent. But if, say, a judge decides to listen to one of these comments and they're in a quite high position, they might decide to change a principle if they have the opportunity to do so. So it can have some influence. And then we have stare decisis, which means stand by what has been decided, which is literally the doctrine of precedent, the process that I explained to you, where we have to follow similar decisions for similar cases to ensure consistency. So this might seem like a lot, but it's hopefully you find it relatively easy or interesting to talk about this. Next, we'll have a chat about the reasons for statutory interpretation. So there's several things here, but why do we interpret acts or law? Why do judges do this? So there might be problems that occur during drafting. So when the law is actually being made, when the act is being written, this could include mistakes, and this could include if future circumstances and changes in how society would change and values would change, if that wasn't taken into account. If the law is not clearly expressed or clearly defined, it might be some inconsistent use of wording that's creating issues, or not covering new technology that has come out. It even gets its own dot point because it's a really significant thing in the 21st century. So all of these are self-explanatory, but you want to give examples for yourself, and you will have questions where you will have to give examples of what a mistake would look like. You can choose what kind of example you want to give, but explain questions where, if, for example, if I chose that it doesn't take future circumstances into account, I might need to explain with an example. This is also really good because although these points are really easy, it's difficult to remember all of them, and you need to. So you want to give yourself examples anyway, so that you can make a connection in your mind and remember them, and be able to answer the questions. There might be problems also that occur during the application. So we have the act and we're trying to apply the law, but there is a problem that's arising from this. For example, and we see this with all the stuff with regards to the Constitution, too broad. Not sure what it means. So a judge needs to define what exactly that law, that statute was intending to mean, and all the things that do apply and other things that fall outside of that law. It may be out of date, so already future circumstances have happened, and now it's difficult to apply a law because it is so outdated. Words could be ambiguous or have contradictory meanings, ambiguous meaning unclear, or they might be contradicting each other. This is very very difficult, especially if there's contradictory meanings, and the statute literally contradicts itself. And acts might have gaps which the court literally needs to fill. So it doesn't take into account all circumstances that the law may apply in, not giving a solution for each type of circumstance. And also, meanings of words can, of course, change over time, and that is natural. So you will be looking at some cases and having to give a few examples of some cases that showcase some effects of statutory interpretation, which will be very interesting. Um, so the effects of statutory interpretation. It obviously develops a new precedent. Um, if we are expanding upon the words that are in the act or defining things or adding to it, it will develop a new precedent in a lot of cases. And or words or phrases in the acts are given meaning. So if they are ambiguous or unclear, contradicting meanings, out of date, they are defined again by judges. And also, of course, the scope of legislation can be restricted or expanded. So we might have a judge, and we'll talk about this soon as well. A judge that is a judicial activist and he wants to expand the rights that fall under the law. So if he says, oh, okay, this doesn't say which technology the Commonwealth can legislate around, but I think this is really broad, so I'll expand it to practically all types of technology. Now I've just expanded now I've just restricted the Commonwealth's ability to legislate, but I've expanded like uh, the people's rights around it, and or expanded the state's powers to legislate around that area. So inevitably, it's either going to restrict or expand practically every time because by doing an interpretation, it's going to have that effect inevitably, either expanding how the law operates or decreasing its operation. So you might even get questions where you have to interpret which of these would be relevant. Either way, you need to remember all three effects. Um, and next, we'll look at the factors that affect courts in lawmaking. So this will make a lot more sense. It will make it easier for you to make sense of what we just looked at before. So we'll look at the doctrine of precedent, judicial conservatism, activism, costs, and requirement for standing. A lot of this is very easy, knowing that we've already discussed doctrine of precedent, we've already discussed cost, we've already discussed the requirement for standing. So it's not too many new terms here. So the doctrine of precedent, we've defined it and discussed it. How does it affect courts and lawmaking? For all of these 5 points, you will need to also be able to evaluate questions. So some strengths of the doctrine of precedent. Of course, it ensures consistency and fairness because it's ensuring that all cases that are similar or the same, they are treated in the same way. Everyone should know or be aware of what the outcome will be for them if taking something to court, if there is a common law precedent that is already in operation. Also, by looking at past cases, litigants therefore can judge how their case is likely to be decided. They can decide not to take it to court or take it to court based on the information that they have. And courts can develop law where Parliament has not yet created statutes. So we said if there is no pre-existing law, the courts can literally develop common law principles in that area and develop a doctrine of precedent in that area. What will Parliament probably do in response is they'll see that this has happened and they will choose to legislate quite quickly because there's a gap in the law that has been discovered through a court case. So if Parliament does legislate, in this area where a precedent was developed but there's no existing law, they might still legislate similarly to the court's decision, or they might choose to do something completely different and legislate against the court's decision. If that were the case, then of course the Commonwealth or the state law is taking priority over the court's decision. So in that case, if there are future cases with the same problem, the courts will now have to use the laws that the parliament has now created, and they cannot use that precedent that they developed anymore. And then what are some weaknesses? So it can be inefficient because in order to change the law and keep it updated, the litigants have to bring a case before the court. Um, so this is not an efficient process because, again, courts are not proactive, they are reactive. Someone needs to bring cases. They cannot actively fill in gaps in the law, or and there are lots of those, or interpret statutes, and they have to wait for someone with standing and being able to afford it. It is also difficult to know when a judge may decide to distinguish a case, and this is where the judge will essentially say, this case is different. It has different circumstances, slightly or a lot, to the circumstances in which the doctrine of precedent was developed for that case. So a judge can still be able to develop new common law if they say that the facts of this case are too different from the one in which the principle you want me to use was established. And that can happen. And it's quite, it's quite difficult to determine if the differences in my circumstances are enough to prompt them to say that, I can't actually, apply that. I have to interpret everything fresh. And another weakness is that this is dependent on cases coming before the court, which is expensive and time consuming. And that relates to the first point there. So next we'll have a look at factors that affect courts in lawmaking. So this is judicial conservatism and activism, two very easy terms. Students love this. They're pretty much opposites of each other. Conservatism, as it sounds, it relates to the idea that judges should demonstrate caution when making decisions and rulings that could lead to significant law changes. Hence, they should be more hesitant in ever expanding laws or making broad interpretations, and they should stick to the most conservative approach. So they try to maintain stability and leave the lawmaking to Parliament. They believe that lawmaking is the responsibility of Parliament and not their own. Therefore, conservative judges will often make the most limiting decisions and try to get Parliament to legislate. They will be hesitant to make any real change. It restricts the ability of courts to consider social or political factors or to be proactive in changing the law. They try not to change the law where they can, and they're not very good at taking into account societal factors. Judicial activism is the opposite. These are our proactive judges. The idea that the courts or judges should consider a variety of social and political factors when interpreting acts and deciding cases. So it allows them to recognize the rights of people and community views and make more fair judgments. They will change laws and they will try to consider all the circumstances and be proactive in changing the law. It can also lead to more appeals, however, and lead to radical changes that don't sit well with the community. The parliament may also have to interfere and change laws to remove some of these decisions. Yeah, you see that how in green and in red is your strengths and weaknesses, because remember, we need to be able to evaluate for these. So judicial activism is, of course, way better because we need laws to keep up with the time. Parliament isn't going to do everything for us. We need common law and doctrine of precedent to be developed as well. Even if we can have some appeals and some dissatisfaction, this is, of course, better than not doing anything and things remaining the same over time. So next we have the cost of bringing case to court. So of course, taking a case to court can be very expensive, and this can prevent individuals, or they may not even be able to afford such costs, and they couldn't qualify for legal aid. We know that legal aid, you need to have very low income. Income merits test is very difficult to meet. And for civil cases, not much support at all, mainly focused on criminal. So remembering that courts can only make law on cases that come before them. We've already discussed that in this session. So of course, some strengths are that the cost can discourage frivolous or unbased claims, just trying to go to court just because you can. A lot of people might get upset about something small and say, I'll take you to court. But no, they won't because it's expensive. So this prevents backlog for the courts and makes sure that only claims that should be heard really come to courts, hopefully, for the most part. And it can encourage parties to use alternative methods or other institutions as well. There's no reason to overload the courts if the matter is simple enough and it can be resolved through alternative dispute resolution. We do want to encourage that by raising the costs of the courts so that people are more likely to seek out other avenues. Some weaknesses, costs can deter the litigants, so people trying to pursue claims who cannot afford such costs from pursuing their case or rights in the court. And then we can't have statutory interpretation because the case doesn't come. And then we have someone who has, say, suffered a breach of civil rights and they're not doing anything about it and it's not corrected. It can also deter parties from pursuing the appeal process, very costly, and even cost money to file a claim for an appeal, not knowing if it's going to be approved or not. And decisions in that case cannot be corrected. Not very fair. Um, and then we have our requirement for standing that we've also discussed in some detail today. This is referring to the idea that the litigant has to be directly affected by the issues involved in the case for the court to be able to hear the case. Very self-explanatory. We're making sure that cases only go to court if people are genuinely affected by an issue and it needs to be fixed because it has affected them and it needs to be resolved for that reason, not just anyone that wants to bring a case for some kind of personal reasons or advocacy. It makes sure that people not directly affected have to seek other avenues, such as lobbying parliament, petitions, demonstrations, which we'll have a look at. And people who have a general interest in a case are unfortunately disadvantaged because they can't pursue the case because they don't have standing. And there could have been lots of potential improvements and smart decisions to laws that could have been made by listening to people with just intellectual interest in the case. This is lost because they don't have standing and they're not able to contribute to that discussion. Another difficult concept we'll go through. So the relationship between courts and parliament, how they influence each other. Supremacy of parliament, it's very straightforward. Parliament is the supreme lawmaking body. Courts ways of influencing parliament. Statutory interpretation, another way that courts influence parliament, and codification and abrogation of common law, which is done by parliament. So with regards to the supremacy of Parliament, it's important to understand, as I mentioned, that Parliament is the supreme lawmaking body. They're able to change and make laws as they please as long as it's within their constitutional power. Therefore, as I already established that they can legislate to confirm or override, essentially make invalid court decisions with their laws, as long as it's within their power. They can also even pass legislation to change the jurisdiction of the courts. As long as they stick to what's in the Constitution, that courts have to be separate and independent, they can still change their jurisdiction, though. So all the ways in which they can influence the courts in a negative way, limiting their powers. Now, how about the courts? How do they limit Parliament, influence Parliament? They can make comments when handing down judgments, or obiter dicta comments. The Parliament might listen to this, and the judge might be saying, actually, there's no existing law in this area. You should create some laws in this area. Parliament may listen and create a law in that area with regards to the case. And they may make comments when handing down a statement or obiter dictum. So this is referring to that. Comments. And these are opinions or statements that don't affect the outcome or judgment of the case, but they can try to incite some change. So key concepts, just obiter dicta under how courts influence Parliament for now. And Parliament as the supreme lawmaking body being able to override courts' decisions and doctrine of precedent. Next, we have statutory interpretation. Of course, courts are responsible for applying the law, and therefore applying acts or statutes is very important. So, courts, as we discussed, can interpret Parliament law, and being able to clarify words, phrases, legislation, expand or limit the scope of legislation. So they can quite literally change the operation of Parliament's law, making it broader or more narrow, depending on the wording that Parliament has chosen. And then, of course, if this affects Parliament in a negative manner, they will have to legislate again and try to change that and be more consistent and be more clear next time. But they can literally affect the operation of laws as long as a case comes before them. Then, of course, we've got codification and abrogation of common law. So, codifying is where Parliament passes laws that confirm precedents set by courts and they become part of legislation. So, a common law decision, Parliament agreed with it, there was no law existing in that area, they decide to pass a law that follows on from the principle that the courts made in that case. Therefore, in establishing that doctrine of precedent, making it part of legislation, showing support for the legal principle. So, of course, abrogation will be the opposite, where they pass legislation that overrides or removes or abrogates a precedent set by a court because they disagree with it. The only exception is they cannot do this for high court decisions based on constitutional issues because that is within the high court's jurisdiction. Next, we have reasons for law reform. Why should laws change? There might be changes in societal values or attitudes, changes to social, economic, and political conditions, significant events, and a greater need for protection, or changes in technology. So we won't have additional information on it, but just think about how if values change and people's attitudes change, some laws will become inappropriate or consider that they should be updated to keep up with the changes. Of course, social, economic, and political conditions, just consider, for instance, for example, how inflation and the cost of living crisis should be dictating a change in law reform, some law reform, but it's not really happening. But that's a great example. And significant events and greater need for protection. So might even be worldwide events of, say, terrorism and awful crimes that lead to a perceived greater need for protection, and then that goes and becomes part of legislation. Changes in technology is a constant reason as well, with lots more technology emerging and needing to be controlled. Just consider AI. We need more laws to make sure it doesn't get out of hand, and there's no legislation, not enough legislation around it, so it therefore needs to be created. So you need to be able to define law reform, and all four reasons for law reform you need to know and be able to give examples and describe. So there was also reasons for law reform. Why are they changing? Why are the laws changing? And these are ways that the public can influence a change in the law by petitions or demonstrations, and then court cases. So how do the people influence law reform? In terms of petitions, these are simply formal or written requests to Parliament to take action in relation to a law in need of reform. It could be in paper form or it could be electronic. That's getting obviously more popular. So you've all heard of petitions. They're trying to get a bunch of people to sign for that change and therefore to influence the reform to happen. What's great about it in terms of strengths? It's very simple, easy, not expensive. We can get lots and lots of votes for law reform very, very quickly. And another strength is if the petition reaches Parliament and is given to Parliament, they have to present or table the petition in Parliament. And they will unavoidably see it and have to think about it and consider a potential law reform or change to the law. Some weaknesses are that Parliament receives hundreds, if not thousands, of these, and they have also no obligation to implement the law reform. So they might even not know about the petition because there's too many, and they might just not want to go through with it, and they don't have to. Similarly, the influence of the success of the petition could also depend on who tables it in Parliament. Next, we have demonstrations. This is where a group or groups of people come together to express dissatisfaction with laws. It can be an effective method of alerting the government to the need for laws to change. So you see demonstrations in happening in public where a group of people comes together and almost like a semi-protest, but a protest is like the more potentially drastic version. Can be a more drastic version of that. But this is what happens in demonstrations as a weakness. They can turn violent. This is obviously a bad thing, and it makes them ineffective. Parliament is not likely to take it seriously if people are violent or seem crazy and very irrational. It can also be hard to plan or organize. Many people may not show up, and it could be impacted by factors such as weather. So it's difficult to get a lot of people in one place, and you do need a lot of people in one place for this to be effective. And in terms of strengths, popular demonstrations can attract lots of media attention, making sure this gets to politicians, and it can raise social awareness and spark even more debate and discussion in society and trying to implement law reform. Um, Lastly, we have court cases, of course, because people can take cases to court to try to spark change via common precedent if there is no existing law or in that area, or they could try to even see what the judge can do. They might even try to get the judge to comment, make some obiter dicta comments, or if it's unfair or unconstitutional. So, what are some strengths? They can clarify legislation that isn't clear and expand or restrict its scope of operation, and that can be in favor of the individual trying to influence law reform. Judges are, of course, politically independent, so they will make rulings on the law rather than political pressure. And similarly, we need standing as a disadvantage, we need time and cost, um, and the judges will only be able to make any interpretation or change if the case comes before them. So, lastly, you need to know about the role of the media, and this is broken down into traditional and social media. Traditional media include your outlets like newspapers, TV, and radio, things that have been around for a long time. And these can be used to spread political information, examine, discuss, and inform people about legal issues and also law changes. This is the mode of media that reaches the most amount of people and reaches to even very young populations and very old populations, likely, particularly television. Then the role of social media, such as in your internet tools and platforms, and you can't define it just saying social media. But it is more intended to communicate information, comments, and opinions. It can connect people, including governments and politicians, and inform them on a range of legal and global issues. It can have a really wide reach, and it can spark debates and conversations in society. And that can be used to try to influence law reform and raise social awareness. Lastly, have a look at the VLRC. It's an independent government funded organization that you will study, and they monitor and essentially coordinate law reform activity in Victoria and advise the government on ways to improve and update law. They're able to conduct comprehensive reviews into an area where potential law reform may be needed if the government initiates this, and they have direct connections to Parliament through the Attorney General. Their reports will all be tabled in Parliament and will be reviewed by Parliament, but the Parliament does not have to follow the recommendations. They have no obligation. So, but they're also government funding, which there is a consideration that this is a government agenda. They can pretend that they care about an issue and investigate it, but really they don't care, and they're just funding VLRC to investigate, to appear like they're caring or trying to do something. Unfortunately, in terms of Parliament responding to law reform, they can do this pretty well because the key points we need to know, and you will study later in the year in more detail, they are elected and the supreme lawmaking body. We discussed this, directly chosen by the people, have more power compared to the courts, quite literally in most cases. Parliament can investigate the need for law reform, such as through VLRCs, and Parliament can respond quickly to a need for legislation. In terms of courts responding to law reform, judges can make decisions without political pressures because they are independent from parliament, and we know judicial power is kept separate from administrative and legislative, for the most part, in theory. They can declare legislation ultra vires in the High Court beyond powers of the Commonwealth Parliament if it breaches the Constitution or the lawmaking powers of goes outside the lawmaking powers of the Commonwealth. And they can also highlight problems and raise awareness. They can point out things that are wrong in their obiter dicta, comments made, by the way, as part of a court case, and try to raise awareness and get the Parliament to notice and the public to take notice of that. Okay, so that's all from me. Congratulations on getting through of legal studies for this legal studies units 3 and 4 lecture. I hope you found that very helpful, and it's really helping you consolidate and also get a head start on unit 4. Thank you so much, everyone, for watching, and best of luck with legal studies and the upcoming exam. Thank you, everyone.